With an upcoming preliminary hearing right around the corner, we delve into some of the latest details in the Bryan Kohberger criminal case, including why the defense is so interested in a surviving roommate. Retired FBI agent and attorney Bobby Chacon discusses. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, so before we even begin, let me just first apologize for the background. I kind of look like the Supreme Leader from the Star Wars movies. It's a work in progress. We've heard your comments. We're trying to figure it out. In the meantime, let's get into the Bryan Kohberger case, because this is something we haven't focused on in a little bit, and we really should. As we know, the 28-year-old former criminology student is charged with 4 counts of first-degree murder and burglary in connection with the brutal slayings of 4 University of Idaho students back in November of 2022. Kaylee Gonsalves, Madison Mogan, Zahner Kernodle, and Ethan Chapin. And we are all anticipating what the prosecution is going to present in Kohberger's upcoming preliminary hearing, which is scheduled for the week of June 26th. As we know, preliminary hearings are the opportunity for the prosecution to present evidence of probable cause that he committed these crimes, all in support of these charges, also that this case can ultimately proceed to trial. That's the purpose of a preliminary hearing. This is the prosecution's burden to basically show their hand. But as we know, the defense can cross-examine these witnesses, the state's witnesses, maybe even present their own evidence. So it's really interesting. So as we wait for all that, there have now been some recent developments that I want to get into. And that brings me right now to retired FBI agent and attorney Bobby Chacon. Bobby, so good to see you. Friend of the program. Haven't seen you on Sidebar in quite some time, so it's good to have you back.
It's good to be back, Jesse. Thanks a lot.
Yeah, so let's start with the major development. The major development regarding Bethany Funk. Bethany Funk was one of the 2 surviving roommates in that house. She was in the house when the killings happened in the early morning hours of November 13th. Now, Kohberger's defense originally subpoenaed her to appear at the preliminary hearing, but then both sides agreed to quash that subpoena because Funk has agreed to be interviewed by the defense in Reno, Nevada, where she lives. Now, the question is, why do they want to speak with her? Well, according to an affidavit that was filed by the defense's criminal investigator, Richard Battanti, wrote, quote, Bethany Funk has information material to the charges against Mr. Kohberger. She was interviewed by police on several occasions. She disclosed things she heard and things she saw. Portions of information Ms. Funk has is exculpatory to the defendant. Ms. Funk's information is unique to her experiences and cannot be provided by another witness. Wow. Okay, so Bobby, as we know, exculpatory means information that would show Bryan Kohberger's innocent. What do you make of that?
Well, yes, it does. That's exactly what exculpatory means. However, the interpretation of whether a piece of testimony is exculpatory or not is very open to interpretation. And so, while the investigator says she has things or stuff that is exculpatory to Bryan Kohberger, that's their interpretation of that, whatever that be. So arguably, in a case like this, in this case in particular, she is probably the most important witness. She's the only living eyewitness, if you want to call her an eyewitness, to the crimes that happened. So she.
Well, also we have Dylan Mortensen, who's the other surviving roommate. She's the one who allegedly saw the killer. So it's, that's a whole separate issue.
Both of these people in the house are really the only 2 eyewitnesses, so to speak. And so the defense is going to want to get into them as much as they can. They want to, what we call dirty them up if they can at trial, and anything that they can get to before trial helps them. So any statement, as part of the discovery process, that the defense gets all of the statements that this witness has made to the police, in any way. And so they've reviewed those statements now, and they want to talk more at length about those things to this witness before cross-examination, because I've had it where in my own statements where defense litigators will get into the littlest detail that you give and try to make you give an inconsistent statement prior to trial, so they can bring that out at trial as an inconsistent statement and maybe look like your memory is bad or you're lying or you really don't know what you're talking about. That's particularly important in cases of like height. I've seen it done in height where the witness will say the guy was about 5'8". And then the police say, well, could he have been 5'8" or 5'10"? And the person says, well, yeah, he could have been 5'8", 5'9", 5'10" in that area. And then the defense says, well, if he could have been 5'8" or 5'10", could he have been 6 foot or 6'1"? And now you've got somebody from 5'8" to 6'1", and they dirty up a witness that way. And then the witness's recollection looks really unreliable. And so in this case, I think what they want to do is they want to get into some of the details of what they told police and try to create seemingly inconsistencies.
Exculpatory is kind of that big word. I mean, it makes you say, basically saying, oh, we can definitively prove that he didn't do it. You know, there's another suspect. We don't know. I mean, exculpatory is the word that they chose. We know that her camp, when they were fighting the subpoena, basically said, quote, that this is without support. There's no further information or detail. And they're basically kind of, watering down what information she has. But here's what we do know. Here's what we do know, Bobby, that she and this other roommate, Dylan Mortensen, were inside that residence at the time of the killings, that they were roommates to the victims. We believe that Miss Funk was in the first floor bedroom. According to the probable cause affidavit that, came out when they ultimately arrested Bryan Kohberger, um, according to Funk, she saw Ethan Chapin and Zana Kernodle at a fraternity house from approximately 9 p.m. on November 12th to 1:45 a.m. on November 13th. She also estimated that at approximately 1:45, both Chapin and Kernodle returned to the residence. She also stated that Chapin didn't live in the King Road residence, which we know he was a guest of Kernodle. And she also said, or was also said in this probable cause affidavit, that Funk and Mortensen both told police that the other occupants of the home returned back November 13th at around 2 a.m. and that they were asleep or at least in their rooms by approximately 4 a.m. But there's one other thing. In the probable cause affidavit, apparently police reviewed forensic downloads from Funk's phone and determined that the homicides occurred between 4 a.m. and 4:25 a.m. So that's important information about the timeline. Remember, according to this criminal investigator, that whatever information Funk has, it's unique to her. Is there anything about that, the fact that she's so instrumental in putting the timeline, that the defense is trying to chip away at? Because if they can say the killings didn't happen at these times or her timeline's wrong, that may help Bryan Kohberger.
Sure, it may help him, but it's hard to see how that can be exculpatory. In other words, unless they're prepared to prove that Bryan Kohberger was somewhere else at that time, if they can say, oh, well, it must have happened between here and here, but we have proof that Bryan was over here at that time, that can conceivably be exculpatory. But oftentimes the defense will say something like, well, this proves that there might have been somebody else in the house or something like that. And that's not necessarily exculpatory. If there was somebody else involved in the crime, that's not necessarily exculpatory to this defendant. They might be trying to say that, you have video of his Elantra in a certain place at a certain time. And if the crimes happened here, how could he have been in that house when his Elantra is on video over here at that time? So they're trying to play with the timeline, and they may think they have something like that where if you're saying this is him in this Elantra, which we're going to say it is, well then the times don't match because the Elantra's on video over here. And now I don't agree that that's what the timeline shows, but that may be the line that they're going down.
The fact that they want to interview her now, which I'm not even clear if it's a deposition, it doesn't appear, it may be just an interview, is the goal there. I think it's to see what information she has that may ultimately lead them toward another path. Whatever she says, okay, now we know where we can find additional evidence that maybe we want to show at a preliminary hearing. Maybe we don't need Bethany Funk anymore to testify at a preliminary hearing, but she can give us information and evidence that we can then present. You think that's what's going on here for that interview in Nevada?
Well, I think it's possible. It's also unusual. I mean, look, the defense usually gets all the statements from a witness, and then the first chance they get. I mean, depositions are generally the purview of a civil trial because most judges want civil trials to settle. trial always concerned me and the prosecutors that I worked with, because the more statements a witness gives, the more chance something is going to look inconsistent or contradictory. And so we always tried to lock our witnesses into statements and then just lock them down and give no more statements. Don't talk to the press. Don't do anything that's going to maybe compromise the statements you've already given, particularly in a grand jury, because that's sworn statements. That's a sworn testimony. And then you always get a witness confronted by the defense by their grand jury testimony. If their grand jury testimony doesn't exactly match up to their trial testimony, then they start to pick at those differences. So yeah, I think that I don't know what else she could give them as far as leads that lead them to other things. I think you're right. I think the only thing that is going to be the timeline. They're going to try to pick apart the timeline because that's really what she offers. Because the one surviving roommate saw him supposedly, allegedly, and this witness is more about the timeline. So they may be trying to find inconsistencies in the police timeline.
Unless she's texted something or heard something that would indicate there was another party in that house that wasn't Bryan Kohberger, that's purely speculation at this point. I am curious, two things. One, there's been a back and forth about whether or not we're even going to have a preliminary hearing, whether or not prosecutors in Idaho are behind the scenes impaneling a grand jury to see if there's enough probable cause. Because if you get a grand jury to come forward with an indictment, you don't need a preliminary hearing. Grand jury would be in secret. Really, the defense wouldn't have an opportunity to present witnesses. They wouldn't have an opportunity to cross-examine the prosecution's witnesses. Exculpatory evidence would have to be shown to a grand jury, but I am curious if you think that might be happening, a grand jury is going to be impaneled, or if we're actually going to see the preliminary hearing. What do you think?
I mean, at this point, I think you'll probably see it. Only because I think if they did impanel a grand jury, I think we would have heard about it by now. I know grand jury proceedings are in secret, but grand juries themselves are not secret. So you'd have to have grand juries showing up at the courthouse, and the media is monitoring everything. You would have seen people coming and going. And grand juries sit, and sometimes they hear more than one case. But I think I just from my mind, I think we would have heard about it. I mean, I hope they do. I mean, I always preferred an indictment over going to trial on a complaint, because you do have, I mean, we actually referred to them as probable cause hearings, as preliminary hearings, because that's really the only issue is the probable cause. And it's kind of a low bar, even though it's a low bar for the prosecution, because it's not beyond a reasonable doubt. It's probable cause. So I didn't like having a trail of prior testimony to any of my witnesses, because again, even the most solid witness can be tripped up on prior statements and stuff. And so I don't know. I think that the probable hearing or the preliminary hearing will go forward. But you're right. They could have a grand jury. And if they do, that's going to delay everything, because once the grand jury indicts, then a new timeline starts. But I think that
And look, it'll be a whole question if Bethany Funk actually is eventually compelled to testify in this kind of hearing or at a trial. We can deal with that at a separate time. Before I let you go, I did want to ask you about some latest reporting from the Idaho Statesman, which I found absolutely fascinating. Apparently, the Pennsylvania school district where Bryan Kohberger attended and where he worked, they turned over his student and employment records as part of a court-ordered subpoena. Now, it's my understanding that we don't know whether it was the prosecution or Kohberger's defense that requested this information. We know that Kohberger graduated Pleasant Valley High School in 2013, and then he had worked for the public school district as a part-time security guard or officer from 2016 to 2021. I'm curious why this information is relevant. If you think about it, the killings happened in 2022. Where he was working, what he was going to school, why would that be important to the case again of him killing these 4 individuals?
the only thing I can think of is, it could show prior similar behavior. We used to call prior bad acts, but so a lot of this case, since he didn't have really direct relationships with the victims that can be shown, they're going to rely a lot on the stalking behavior, as we've seen reported, the alleged stalking behavior of Bryan Kohberger. So if he did have, say, in his school records, and this is as recent as 2021, he worked for that school district. So this is kind of recent behavior. So if he had, say, allegations of stalking behavior against him at his prior school, at his prior employer, that could be considered possibly relevant. I don't know if the judge would let it in, but that could be considered relevant. So they probably want to see what kind of guy he was, because this is all about what kind of guy he was, right? The jury's going to be like, why out of the blue does he viciously murder 4 people that he really didn't even know? So if, and again, the stalking behavior has been cited in some of the reporting in this case. So I think that if he was, alleged to have done that at his prior employer up until right in 2021, it could be relevant, and they could want to know about that.
Yeah, I mean, the former Pleasant Valley security, I think he's a supervisor, said that Kohberger, would drive up, he'd check all the doors, he hits the security button, basically patrolling. So you might very well be right what the significance of that is. Bobby Chacon, thank you so much. Appreciate you taking the time, sir.
Always great to be with you, Jesse. Thanks.